Hello and welcome to the next series in SBA's Lunch and Learn webinars. Today we're talking about relief from forfeiture, including a review of the test, an updated decision applying the test, as well as a recent decision which has changed the landscape of relief from forfeiture in the accident benefits context. As a recap for those who may not know, we are a firm made up of 26 lawyers practicing exclusively in insurance defense and other insurance-based matters. We have 3 offices, one in Toronto, one in Kitchener, and one in London. My name is Lisa Code, and I practice primarily in the area of insurance tort litigation, with a focus on automobile insurance defense, premises liability, and coverage and policy wording.
And my name is Emily Rasick. I'm an associate here at SBA. My practice is primarily dedicated to motor vehicle accident cases in both tort and accident benefits. If you have any questions during the webinar, please put them in the chat. If there's time at the end, we will answer questions. If not, we'll just ask you to contact us and we will answer by email. I'll turn it over to Lisa now to start us off.
Now, just so you know, this webinar is being recorded and will be up next week, so feel free to share it with a colleague or review it at your leisure. Now, the agenda today is that we are going to go through an introduction to relief from forfeiture, then review the test, then go through a recent application of the test, and finally review the test's consideration at the lab. Now, what is relief from forfeiture? If you consider a breach of contract scenario where, although the breach in question is minor, the consequence of that breach is that the person stands to lose all of their benefits under the agreement. Relief of forfeiture is a remedy that refers to the power of the court to step in and protect that person from this outcome, where strict adherence to the terms of the contract would either be unfair or inequitable. To be put simply, in insurance coverage disputes, it is an equitable and highly discretionary remedy that can protect an insured from the consequences of their breaches or mistakes. Now, this remedy has been around for a long time. Courts of equity have always had the power to relieve against forfeiture of property due to a breach of contract. That power is now codified in various statutes dealing with specific kinds of contracts. With respect to insurance contracts, it is found under Section 129 of the Insurance Act. As well, it has been given a more general expression in Section 98 of the Courts of Justice Act. Now let's discuss the 2 legislative provisions that give power to a court to grant relief from forfeiture. Section 29 falls within Part 3 of the Insurance Act, and under that part, Section 122 provides that part applies to all insurance contracts except for accident and sickness insurance, life insurance, and marine insurance. Therefore, the court's power to grant relief from forfeiture under Section 129 of the Insurance Act is not available to these types of insurance contracts. The provision itself does not give judges a broad discretion to grant relief from forfeiture. In Williams versus York Fire and Casualty Insurance, a 2007 Court of Appeal decision, the court found that the power is a narrow one pertaining only to those policy conditions, both statutory conditions and contractual conditions, that relate to the proof of loss. It does not apply generally to all policy conditions. In other words, it's only applying to breaches of conditions after the loss occurs, for example, timing of notice. Section 98 of the Courts of Justice Act is a broader provision covering breaches of conditions both before and after the loss. In Kozel versus Personal Insurance Company, a 2014 Court of Appeal decision, The court found that relief from forfeiture pursuant to Section 98 of the Courts of Justice Act is available to contracts regulated by the Insurance Act in addition to 129. That means that Section 98 is available to those insurance contracts Part 3 does not apply to, as well as breaches of conditions occurring prior to the loss. For example, expiry or suspension of a driver's license or failure to pay premiums. The relief from forfeiture test has been developed by the court over the years. The first step is a threshold question. Does the breach constitute imperfect compliance with a policy term or non-compliance with a condition precedent to coverage? Notably, courts have consistently stated that relief from forfeiture is not available where the breach is one of non-compliance with a condition precedent to coverage. Now, where the court determines that the breach is one of imperfect compliance, the court will move on to the three-pronged test, which consists of a consideration of the facts specific to each case in the context of the three factors: conduct of the insured, gravity of the breach, and disparity between the property forfeited versus the damage caused by the breach. Now, the onus of proof is on the party seeking the relief itself. The threshold question is crucial. If the breach is in perfect compliance, then the analysis continues on to the three-pronged test. If not, the analysis is over and the remedy can't be granted. Imperfect compliance is a breach of a condition or term that is incidental to the contract. Whereas Justice McLaughlin held in Falk Brothers Industries Limited versus Elance Steel Fabricating, which is a 1989 Supreme Court of Canada decision, that a breach constitutes non-compliance with a condition precedent only in rare cases and where the breach is substantial and prejudices the insurer. An example of how the determination of whether the same breach can be imperfect compliance versus non-compliance, depending on the facts, can be found in comparing the decisions of Falk Brothers Industries and Stewart versus Hutchins. In Falk Brothers Industries, the issue was whether the claimant's failure to give notice of the claim to the insurer within a prescribed period precluded an award of relief against forfeiture. Justice McLaughlin noted that failure to give timely notice of a claim has been viewed by the courts as imperfect compliance, as it is less serious of a breach than, for example, failing to bring an action in a timely manner. Whereas in Stewart versus Hutchins, the issue was whether a broker failed to report a claim within a time frame required under the claims made policy precluded an award of relief against forfeiture. Justice Moldover, as he then was, held the failure of a broker to report a claim within the policy period amounted to non-compliance with a condition precedent to coverage. In making the decision, he stressed the difference between occurrence policies and claims made policies. The decision is integral to the determination of whether the time frame to report a claim is a term of the contract or a condition precedent to the contract. Occurrence policy covers events that happen during the policy period, regardless of whether the claim is filed. Therefore, the term is incidental to the contract, and a late reporting breach is imperfect compliance. A claims made policy covers claims that are made and reported during the policy period. Therefore, the term is a condition precedent to the contract, and late reporting of the breach, in particular outside the time frame of the contract, is non-compliance with a condition precedent. These two cases illustrate an analysis of how a breach of the same term can result in different outcomes depending on the facts of the case. The relief from forfeiture test is a case-by-case analysis of the facts in the context of these three factors. The Ontario Court of Appeal discussed these factors in the more recent decision of Monk versus Farmers Mutual Insurance Company, which is a 2019 Ontario Court of Appeal decision, leave to appeal denied. In Monk, it was dealing with a fire loss of a log home in 2008, where the insured notified the broker of the loss in 2011. However, the insured initially said she notified the broker of the loss 3 times prior to 2011, but each time the broker informed her there was no coverage available. The issue was whether the lengthy delay in reporting the claim precluded relief from forfeiture. At the trial level, the trial judge determined the breach was imperfect compliance with the terms of the contract. But in exercising his discretion in considering the 3 factors, he refused to grant relief from forfeiture. The reasoning was that the insured's conduct in delaying making the claim was not reasonable. The insurer was prejudiced by her conduct. The prejudice was significant, even in light of the amount of money the insured stood to lose. As well, the trial judge found that the insured was attempting to escape the consequences of her late notice by misleading her insurer on the date she discovered the damage. At the appellant level, Justice Brown reviewed the 3-factor test comprehensively in his decision. In doing so, he provided clarification that the party seeking the relief does not need to establish all 3 factors to obtain relief from forfeiture. In reviewing the historical and current case law, Justice Brown noted 2 points emerged. 1, the 3-factor test requires the court to consider and balance all 3 elements in exercising its discretionary power. 2, the examination of the reasonableness of the insured's conduct lies at the heart of the analysis. In analyzing factor 1, the conduct of the insured, Justice Brown noted a party whose conduct is not seen as reasonable will face great difficulty in obtaining relief from forfeiture. The reasonableness part of the test requires a court to consider the nature of the breach, what caused it, and what the insured attempted to do about it. All of the circumstances, including those that explain the act or omission that resulted in the breach, are taken into consideration. For example, was the conduct willful, or was the insured's non-compliance persistent? Here, Ms. Monk failed to inform the insurer contractor about the damage until 2011, which was more than 2.5 years after she initially said she noticed the damage. As well, after the denial of coverage, Ms. Monk attempted to mislead the insurer by taking the position that she did not notice the damage until January 2010. In analyzing the gravity of the breach, the court noted that courts look at both the nature of the breach and the impact of that breach on the contractual rights of the insurer. In Monk, the trial judge held that Ms. Monk's delay in reporting her loss resulted in the insurer suffering several kinds of prejudice. Specifically, the court noted the insurer lost the ability to investigate the circumstances and value the loss at the time of the occurrence. As well, the ability to take early remedial action to reduce the scope of the loss, and the right to maintain a subrogated claim against the at-fault contractor as the action had been statute barred by the time Ms. Monk had reported the loss. Finally, in considering the disparity of property forfeited and the damage caused by the breach, The court noted it must conduct a version of proportionality analysis, which involves comparing the disparity between the loss of coverage and the extent of the damage caused by the insured's breach. In Monk, the loss of coverage was approximately $100,000, which the court found was significant. However, in contrast, the insurer may have been able to recover or mitigate that amount paid out by way of subrogation had there not been a strong limitations defense available to the negligent contractor. In considering and balancing all three factors, the appellate court upheld the trial judge's decision, noting, despite some findings on gravity of the breach not being supported by the evidence, the ultimate finding of prejudice was supported, as was the insured's unreasonable conduct and the disparity between the lost coverage and the damage to the insurer. While the appellate court disagreed that the evidence supported that the delayed notice increased the scope of the loss, the court held that the delay did preclude the insurer's right to maintain a subrogated claim as the limitation period had expired, and the insurer was prejudiced by the limitations defense made. The trial judge also made a strong adverse finding of credibility and his holding against the insured as she attempted to escape the consequences of her late notice by misleading evidence. This was considered by the appellate court to be willful conduct. Justice Brown stated that this was one of the cases where the insured's conduct was not reasonable, and because of it, she could not hope to obtain relief from forfeiture.
The Urban decision is a recent decision applying relief from forfeiture in the tort context. In this case, the applicant was involved in an accident while driving with an expired license. While Security National Insurance acknowledged liability under the policy for the property damage claims arising from the accident, they refused to defend or indemnify him on the basis that he was driving with an expired license at the time of the accident. The applicant argued that he acted with due diligence and sought relief from forfeiture. On appeal, the court granted the application, finding that Mr. Gibbs successfully established a defense of due diligence to the offense of driving without a valid license. Alternatively, the court held that he was entitled to the equitable remedy of relief from forfeiture. In addressing due diligence, the court explained that the defense of due diligence is established where the person accused of an offense either holds a mistaken belief that would render the act or omission innocent if true, or takes all reasonable steps to avoid the particular event. The court emphasized that the test is one of reasonableness, not of perfection. The court held that Mr. Gibbs acted reasonably in maintaining a valid license immediately before its expiry and in attending for a road test approximately 1 month following expiry. The court further found that Mr. Gibbs's belief that his license was covered by the COVID grace period was reasonable, despite being mistaken. Further, the court was persuaded that Mr. Gibbs acted reasonably in trying to reschedule his road test prior to the accident. Accordingly, the court held that Mr. Gibbs established the defense of due diligence to the offense of driving without a valid license. In addressing relief from forfeiture, the court considered the factors to establish relief from forfeiture, as just addressed by Lisa. In applying the first part of the test, the court highlighted that Mr. Gibbs paid his premiums on time, he did not deliberately avoid renewing his license, he reasonably believed the COVID grace period applied, he did not act in bad faith and cooperated with Security National. He also acted reasonably after the accident by retaining counsel to defend his personal injury action so that Security National would not be prejudiced if it assumed his defense. Regarding the second part of the test, the court found Mr. Gibbs's breach of driving with an expired license to be minor and not fundamental to the contract. The court noted that he held a valid license from the Bahamas and was an experienced driver. Further, his license expired just 34 days before the province-wide grace period took effect. Considering the third factor, the court found a significant disparity between the value of the coverage forfeited and the damage caused by Mr. Gibbs's breach. The court found it difficult to identify any damage or prejudice caused to Security National by Mr. Gibbs's breach. In contrast, denying Mr. Gibbs relief would leave him facing the loss of at least $800,000 in insurance coverage, the burden of funding his own defense costs, potential personal indemnification of the plaintiff, subrogation claims, and exposure of his personal assets. The court determined that the disparity was great, and Mr. Gibbs was therefore entitled to the remedy of relief from forfeiture. This case signals that a reasonable misapprehension of facts, or acting with reasonable care, such as attempting to schedule a road test, may be sufficient to excuse non-compliance with licensing requirements. As a brief recap, relief from forfeiture is an equitable and highly discretionary remedy where there is imperfect compliance with the term of a policy. The onus is on the party seeking relief. Relief is available where breaches occur before the loss pursuant to Section 98 of the Courts of Justice Act and after the loss pursuant to Section 129 of the Insurance Act. Non-compliance with the condition precedent is rare and will only apply where the breach is substantial and prejudices the insurer. Generally, insurers must provide strong, substantiated evidence when disputing policyholder actions. Relying solely on technical, imperfect compliance without considering factors such as fairness and good faith may be insufficient to deny coverage. Generally, coverage determinations involving a breach of a condition should also consider whether the insured might also be entitled to relief against forfeiture, as it's conceivable that failure to do so could lead to a bad faith claim. While the onus of proof is on the insured, as they are the ones seeking relief, the insurer is still required to prove actual prejudice to oppose the remedy. In post-COVID contexts where grace periods or administrative backlogs may be factors, insurers should approach claim denials cautiously due to the risk of judicial intervention on equitable grounds. Ultimately, the circumstances must be examined on a case-by-case basis to determine whether relief from forfeiture is applicable. Turning to accident benefits, the bought bill decision is a recent decision that will be of interest to those working in accident benefits. In bought bill, the applicants were involved in an automobile accident. They had a policy with Economical and a policy with Heartland, which included enhanced benefits. The applicants retained counsel who submitted an accident benefits package to Economical. After the OCF1 was sent to Economical, Heartland denied the claim on the basis that a particular endorsement that applies to all insurance contracts that includes optional benefits, the OPCF 47, prevented Heartland from providing optional benefits to an insured who had already applied for accident benefits with another insurer. Of note, Heartland had notice of the collision and of the insured's intention to pursue accident benefits with them prior to the OCF1 being sent to Economical. The issue is whether the applicants were entitled to relief from forfeiture related to their application to Heartland for accident benefits. Of note, previously, in disputes where an equitable remedy was pled, the lot typically found it did not have the power to grant them by virtue of being a tribunal rather than a court. At the lot, adjudicator Norris granted relief from forfeiture under Section 129 of the Insurance Act. He found that the factors to consider when deliberating on whether to grant relief from forfeiture all weighed in favor of granting the relief. Specifically, there was no evidence of dubious behavior by the insureds or their counsel. Rather, they made an innocent mistake. Within fewer than 4 weeks of making the mistake, the insureds made a written request for Heartland to reconsider their position. The gravity of the breach also weighed in favor of the insureds. Permitting Heartland to avoid paying benefits due to the insured's error would provide a windfall for Heartland, given it collected premiums without having to uphold the contractual obligation relative to those payments. Whereas, permitting the insureds to rescind their claim with Economical and file a new claim with Heartland caused no additional harm, as Heartland would otherwise have been liable for the claim. The disparity between the value forfeited and the damage caused also weighed in favor of the insureds. While he noted that Section 129 uses the term court, he found it would be unfair and inconsistent with the consumer protection mandate of the SABS regime to exclude the lot from this definition, given it had exclusive jurisdiction to adjudicate these disputes. This decision was reconsidered by the lot. Where the decision and the reconsideration decision parted ways is on the question of whether the lot had the jurisdiction to apply Section 129. Vice Chair Joel found that the term court in this section had repeatedly been found not to include the lot or other tribunals. Thus, he found that the insureds were not entitled to relief from forfeiture. On appeal, the court restored adjudicator Norris's decision granting the insureds relief from forfeiture. Fundamental to the decision was the fact that the SABS is consumer protection legislation, which must be interpreted to reduce economic dislocation and hardship for victims of motor vehicle accidents. Citing the Court of Appeal decision Tomek versus Economical, the court held that interpretations should advance, not undermine, the SAB's public policy objectives. Thus, the term court was held not to be read narrowly. In further support of its decision, the court held that under the License Appeal Tribunal Act, the LAT has broad jurisdiction and powers to address questions of law or fact, including the application of Section 129. Applying Botbill, the divisional court found that first, Section 129 of the Act codifies the doctrine of relief from forfeiture. Second, this section does not include a definition of the word court. And third, Section 122 of the Act states that Part 3 of the Act applies to every contract of insurance in Ontario, subject to 3 exceptions, none of which were auto insurance policies. The divisional court concluded that the LAT therefore had jurisdiction to apply Section 129 of the Act and grant the remedy of relief from forfeiture. The key takeaways from this decision is that relief from forfeiture is now available at the LAT. There are 3 recent decisions citing Botbill, however, they do not address relief from forfeiture. Thus, there is some uncertainty as to how these decisions will be applied by adjudicators going forward. We foresee that relief from forfeiture will likely be engaged in 4 circumstances. The first being where optional benefits are involved, as in Botbill. Applicants will likely succeed given this decision. It may also be used in circumstances involving late applications or notice pursuant to Section 32, which includes the late submission of an OCF1. It may also apply in circumstances involving delayed or late action by uninsured. So, for example, delays in submitting an OCF3. The applicant may seek relief for Section 33 noncompliance. However, this is unlikely since Section 33 sub 8 already allows benefits to be restored if the applicant later provides the required information with a reasonable explanation for the delay. While also unlikely, it might also be used as a last-ditch effort for Section 44 noncompliance issues. We see this as ultimately unlikely, given that the main defense in these situations will be that the insurer provided improper notice. Overall, we're not sure to what extent the law will entertain these specific claims. Lastly, relief from forfeiture may be used where specific exclusions under Section 31 of the SABs apply. We specifically reference the new / ought reasonably to have known that they were operating a vehicle while not insured provision pursuant to Section 31 sub 1 sub A sub 1. We also highlight Section 31 sub 1 sub A sub 2, which refers to driving an automobile without a valid driver's license, as was the case in Cozell and Urban. However, we caution that this list is not exhaustive and is speculative given we do not know how receptive the tribunal will be to these arguments. Overall, whether relief from forfeiture is applied will be dependent on the facts of each case. And as a quick reminder, relief is not automatic. It will not be granted as well where there is fraud or willful misrepresentation, willful or persistent noncompliance, or where the insured suffered real prejudice disproportionate to the gravity of the breach. That concludes our Lunch and Learn seminar on relief from forfeiture. Thank you for joining us. If you would like to read more about relief from forfeiture, Shalini from our office and myself have written blogs on the Botbill and Urban decisions, which you can find on our website under blogs. It looks like we have a couple minutes for questions, so we can see what questions we have here.
Okay, it looks like there's one question. It's for the accident benefits in that context. The question is it even worth it to deny a claim where an exclusion under Section 31 of the SABs, specifically if they were driving without a valid driver's license, applies given the decisions you've mentioned?
Yes, I can address that one. So this is an important distinction. While the decisions of Cozell and Urban impose a slight impasse in addressing these claims, that does not mean that a denial should not be considered in the appropriate case. The circumstances, as reiterated by both Lisa and myself throughout the seminar, will need to be examined on a case-by-case basis to determine whether relief is likely or not, or whether a denial should be pursued. Taking the decision in Urban, for example, there were numerous factors that the court highlighted that led to their finding. Specifically, he paid his premiums on time, he did not deliberately avoid renewing his license, He did not act in bad faith, and he was also cooperative, and these all weighed in favor of the insured. So to answer your question, I would have all of this information in my back pocket to assess these claims, and where these are assess them on a case by case basis, applying the factors that we just referenced. And using those tools, you should be able to determine whether or not a denial is appropriate in that specific situation. I hope that answers your
Okay.
question.
It looks as though we've hit 12:30, so we are done for today, and thank you very much for joining us.